Hi everyone, it's Grant Abbott speaking. Tony Anamourlis will be here very shortly to entertain us with his Victorian repartee. But welcome to this estate planning 101 training. Hopefully you can all hear me. Give me your hand up if I'm okay coming through perfectly. So I want to make sure that you're all okay. Thank you very much. Use the Q&A and also the questions if you need be, or the chat room. Today's session is quite a detailed session. It's 2 hours. To be brutally honest, we could easily go over this in a full day if we did a deep dive into the legislation. But we're not going to go into the legislation today. All we're going to do is we're going to go through the broad basics, the practical side of things, and look at some various issues around that. Now, you're probably well aware that if you don't have a will and you die intestate, then all your worldly assets are going to be divided up according to each state's intestacy laws. Generally, if you have a look at them, for example, up here in Queensland, generally it goes to the spouse or the de facto, and maybe proportioned or portioned up between the children and then possibly the parents, depending on who's alive. There's formulas in each of the states on who gets what. The problem is it takes a long time. You need to go through the court. You need to go through a whole process. If it's done by the public trustee, you're looking at maybe a good year and a half, 2 years, and it's going to cost thousands of dollars, which obviously eat into the estate. Surprisingly, more than 50% of Australians don't have a will. And even if we have a look down at the younger level, 25 or 30 young families or people getting together, you really need to ensure that a will is available. Hence, through Abbott Mourly and also like eDocs, we've built a system which we'll go into later. Again, this is not to show the system at this stage. There's plenty of videos around that. But contextually to show you that it's a perfect role for accountants and financial planners to offer wills and even enduring powers of attorney for clients. And so we'll be going through that, how it works from a legal perspective, and also how, if you want, for cases that you feel might be a little bit over your head, how you can engage Abbott Mourly to take over that case for you. You'll prepare the initial documentation, but then we can come and take over that case for you, offer the client directly legal advice, subject to legal professional privilege, and really free you up from that worry. Notwithstanding, you'll still be in a position of charging the client for tax, admin, and the preparation of the documents. But at the end of the day, we're the ones who, it's much the same as in a legal firm. Paralegal prepares all the documents. They don't effectively sign off, so it's the end solicitor who has to sign off. And it's exactly the same, for example, in Abbott-Mourly.com.au. I'm not a practicing solicitor, but I'm a principal of the firm. I'm a non-legal specialist consultant, particularly in the SMSF area. So when I draft up a letter of advice, in order for it to go out and for the claim legal professional privilege, Tony Anamourlis signs off. And it's exactly the same position that you'll be done there. So for all clients, it's absolutely crucial to get a will and ideally an enduring power of attorney. We're going to spend a lot of time today on testamentary trusts and discretionary testamentary trusts. And of course, then there's your superannuation, whether it's through an SMSF or a retail superannuation fund. So we need to plan all of these. I'll spend a little time on SMSFs and super. But again, this is a really good training to ensure that you have a full understanding of wills and also testamentary trusts. And again, where we're going at the moment, we're planning, and the planning can make a huge difference. So the learning outcomes today that you should receive is, once we go through, you'll know what the key is to a perfect estate plan. Secondly, we're going to look at the common terms that are going to come across. it's like anything, whether you're a financial planner, you're talking about an ETF. And if you went out to the general populace and talked ETF, they'd have no idea generally what you're talking about. So we end up having a lot of nomenclatures, short versions. SMSF, a lot of people don't know what SMSF is. So we want to go through those common terms that you're going to find in estate planning. Tony's going to go through, if he's back from his meeting, on why an accountant and financial planner is so important, and why a lot of the wills are effectively defective around Australia, because the accountant and financial planner hasn't been deeply involved in that process. They've simply handed the client on to the lawyer, who probably, if you have a look at it, really doesn't take into account, for example, what happens with the shares of a corporate trustee of a discretionary trust, or shares of a corporate trustee of a self-managed super fund. They don't even factor that into account. So we want to make sure that you're in there. Obviously, tax advice is absolutely crucial, and without proper tax planning, it can make a huge difference. The same with the investment side of the equation from a financial planner. Ideally, we want to see you as the trusted advisor to the estate. So not only will we be doing the planning, but when the client dies, you'll be set up as the advisor to the estate to ensure that all the wishes, all the planning that you've put in place with a client is effectively brought to fruition. And that's an absolutely crucial role, and really can take many months, and it's a per hourly charge there. So that's crucial for that perspective. We won't talk about, I don't think I've got the time to actually show you how to build a will really simply on the light year docs. If I do, I will. But the key there is there's the importance, obviously, of the data capture as well. So, when we have a look at that, it's absolutely crucial for our perspective. So when we go down here, Abbott Mourly, if you do need to go down that track, as I said before, Tony will cover this a little bit later on, but we're able to provide legal advice and legal professional privilege to your client for a set fee. But again, your feature there is absolutely crucial. Your work on preparing that is absolutely crucial. I want to look at who can be an executor and also the trustee. So quite a bit of detail in relation to that. So the executor looks after the initial part of the estate, and then we move over to the trustee of the estate. For the will itself, what's the difference between specific bequests versus primary, secondary, and tertiary beneficiaries? Generally, the primary beneficiary is the first person who'll get it. If they're not alive, it goes to the secondary, and if they're not alive, it goes to tertiary. Generally, most wills you'll see will only go down maybe primary and secondary. We like to take it one step further, and tertiary, just in case primary, secondary happen to be in the same accident. And given COVID this year, I don't think any of us can take anything for granted. We need to make sure we're planning quite a lot. But at the end of the day, it's not your decision; it's your client's decision. But it's nice to know that those solutions are in hand. We're going to have a look at testamentary trusts in quite a bit of detail, and also the benefits of using a testamentary trust, which is absolutely crucial. We're going to look at how to put one in play, whether you should just have one testamentary trust, for example, for 3 children, or have 3 testamentary trusts. We'll look at the pros and cons of that. We'll look at a special disability trust for disabled children. There's an ability through the estate to put up to $500,000 as a gift into the special disability trust. There's tax concessions in there as well, and also there's some Centrelink exclusions as well. So a special disability trust on death is quite crucial. So we'll go through the parameters around that just to give you enough knowledge to understand what's going on. We'll have a look at super, but again, I'm not going to do a deep dive and go into a lot of examples. I did a really good session on SMSF Wills just recently. If you haven't looked at that, go to obviously our strategy centre on Lightyear Docs and pull that up, or just do a search and have a look over that session. We're going to look at family provisions claims as well at the end. So it's nice to set up a lot of this, but we'll also have to be mindful for our clients as to where a family provisions claim may strike us down, or where it may be subject to a strike. And I'm going to look at a simple case study there. So really at the end of the day, after this 2-hour session, you're going to have a really good understanding of all of those. You'll also find in the slides, they're not just bullet points. We've actually taken quite a bit of time. Tony's taken quite a bit of time to write down a lot of the information, which is absolutely crucial. So if I'm breaking up, I'll just make sure that my, microphone is a lot closer. So if that's a little bit better. And sometimes it's also, I know with my situation, it's the other end of the pipe. Like I had a problem the other day, I think with Michael and Ash, when we were doing a shareholders report, that it was getting very fudgy. It wasn't my end, it was their end. In fact, I've got Michael and Tony online. Tony, just want to have a quick word around the estate planning side?
Yeah, hi everyone. What's really important is basically what you have to do is just determine what is important to a person about looking after their family and loved ones when they die, because that's important. And what you've got to do also is create a what's called a blueprint to deliver the desired estate planning goals, and using the right combination of vehicles and life insurance if need be, basically. And also make sure that the plan is simple, not over too excited, and make it certain, easy for all parties to understand before the person dies, basically. And that's one of the key features, basically, in our wills. They're pretty easy to understand, and there's no dramas with that. Can you hear me now?
Yeah, you
Ian,
speak up.
everybody?
Yeah, that's much better. Yeah, perfect.
No, that's fine. And also just ensure that the person or persons left in charge of implementing that plan or that blueprint on behalf of the deceased knows what they're doing, or use experienced advisors to deliver up the plan, basically, and make sure it's tax effective, and also ensure that it complies with the laws of any chance of any legal disruption is minimised, basically. So
From that
taking all
perspective, I think if we have a look at it, there's that list that Tony just talked out. A lot of the important stuff is actually built by you as accountants or financial planners. And I was going through that process before, Tony. I know you'll be looking at a lot of that, but that making sure what's important, creating a blueprint. The good thing about it for accountants and financial planners, you're both really aware of who the client is. You've had a lot of discussions with the clients about a whole lot of general issues. So you already know the client, which is one of the problems about sending a client off to a lawyer, because the client, the lawyer just doesn't know the client. They can take down instructions and deliver something, but again, the actual total time knowing it is very minimal. So that planning that you're doing has to be simple and really take into account all of their circumstances. From the legal side, that last one, making sure it complies with the law and any chance of legal disputation, that's what we'll be getting into a little bit later on. So let me have a look at some of the key terms. So we want to build that plan. We want to structure the plan. We want to deliver the plan to the client, and even the documentation and draft to the client. And then potentially later on, if you need Tony to get involved with the client in order to, or one of our lawyers at Abbott Mourly, in order to provide legal advice around some issues, then we're essentially there. So let's have a look at some of the key terms which are fairly important. A will is a legally valid document that details how a deceased estate is to be distributed amongst their family and charities. Generally, the will needs to be obviously signed off and have two witnesses, and each and every page has to be executed as well. Tony, with the will, I mean, what's your recommendation in terms of how many copies they should have of the original will and who
Yes.
should hold them?
So what usually happens in these circumstances is once the will, the original will has been signed off and initialed, what happens is I make two certified copies of the original will that's been executed. So the original will, if it's requested by the will maker, will go back directly to the will maker. One copy will stay with us, which is a certified copy, and another, of course, will stay with the advisor in his file too, or in his vault. So everybody's got essentially, a copy of the client's will, just in case, the will goes missing or what have you, basically. So
Perfect. And the executor is one of the most important rules and roles to play. And we're going to have a look at the executor a bit later on. It's the person who administers the management of the deceased estate. Just be very careful if you act as, my preference is that if your client hasn't got an executor, because it is a big role, quite often a professional such as an accountant or a planner may step in. You just got to be very careful around that there's a contract for your legal fees that are signed by the testator up front. So there's no disputation later on, because I can tell you any beneficiary who feels as though your fees are out of whack will certainly take a ping at you there. Alternatively, the easier way is to find someone in the family who's the executor and tell the client that you're going to be running alongside them. So you'll ensure as a mentor that everything gets done as required by the will. So executor, good role. I prefer you acting as the administrator of the management or the person helping the executor. The administrator, if there's no executor, then effectively you'll go up to so if the executor has died, and again, this is important to have a chain of executors. If there is no executor, then generally we point an administrator. Do you just want to go through the process of what happens with the administrator and the Supreme Court, Tony?
Yeah, so once the executor essentially proves the will, then what happens is the Supreme Court grants, under its probate division, either letters of administration or grant of probate, basically. So once grant of probate but I'll go into a little bit more detail later on about this. So once probate has been granted, then obviously the executor has to follow what the will essentially states by the will maker in terms of the distribution part of it, and collecting all the assets, all the goods, basically on behalf of the beneficiaries. So and an account has to be kept of that, and then it's distributed, either proportionately or whatever the will says, basically to either the primary the primary beneficiary will usually be the spouse anyway, and if the secondary beneficiaries, which will be basically the kids, if there are any tertiary beneficiaries, for example, like charities or aunts, uncles, whatever, they get distributed on a proportional basis, of course, in accordance with the will.
And if there's no executor,
so if there's no executor at the end of the day, well, you'll have to appoint a public trustee. That's what usually happens,
which means take years and it'll cost a lot of money.
Yeah, that's right. So it's with a public trustee. There's reporting obligations. There's all kinds of things. There's all, the fees are just phenomenal with public trustees at the end of the day. So
I know with my grandmother, when she passed away, the public trustee looked after her estate, and it took 8 years.
Yeah,
and cost, thousands and thousands of dollars. It was just crazy.
It's crazy. I mean, it's just insane, this stuff,
So again, this is the importance of having, as Tony said before, having a plan for succession. That succession, who's executive, if they're not around or they don't want to do it, who's the next and who's the next. Again, go down that level. As Tony said, with the beneficiary, we might have our primary beneficiary, could be 1, 2 or 3 people or even more. And then what we need to do is work out, if they're not alive, what happens to their entitlement under the will. So for example, if it's between, obviously dad dies, goes to mum, she gets 50% of the estate, and then you've got a couple of children who receive 25% each. What happens if one of them are not alive at the time of the probate, which is generally why you have that 30-day window from that perspective. Now, if one of them is not alive, you need to work out, again in this plan, is it going to go back to the other primary beneficiaries in equal proportion, or has that person got their own beneficiary? For example, it might end up going to their children. It'll be put into a testamentary trust. So we've got the primary beneficiary, but as Tony said, the traditional one is it goes to the spouse. If the spouse is not alive, it may go to the children on a proportional basis. But you'll see when we get down to the case study, it's not always that case. In fact, you may end up being in a position that you don't want to give your children anything, which will be interesting when we have a look at family provisions. Probate, just want to go through that really quickly, Tony, because I know we're going to get to your
that's fine.
Infographic shortly.
Well, like I said, probate, the executor applies to the Supreme Court with a whole heap of documents. They've got to go through an affidavit process, all the applications, what the estate's worth, etc., etc. If there's any queries, there'll be requisitions back from the Supreme Court Register's probate division back to the lawyer that's handling, who's acting for the executor at the time, and then further material is submitted until the probate division basically is satisfied. Once it's there, then it gets signed off basically by the registrar, and away you go basically, and then you can start with the executor's solicitors, to evenly spread out basically whatever the will says in terms of, the split of assets.
The initial,
that's a snapshot.
Yeah, the initial administration, I'll have a look at that bit later on, because we have got a slide on the importance of the executor. But just knowing that there is initial administration, we'll look at that shortly. Specific gifts are something that I love providing. The main one is that a specific gift is like a distribution from a trust specifically down to a beneficiary. So, for example, if you can think of a trust, and I'm just generalizing here, but if you think of trust, we might have, for example, dividends or capital gains that we can stream out to one beneficiary. The same thing with specific gifts. We can stream those out to specific beneficiaries, such as if we've got a farm that's owned by mum and dad, and the last to survive there might pass it down to the child who's working and living on the farm, rather than putting it in the larger pot. What happens there is specific gifts. In fact, we were involved through Abbott Mourly with a client who wanted to give $20,000 to each of their children, and then $20,000 to each of the grandchildren who were alive at the time of his death. So that meant that they're specific gifts. So when we have a look at the initial administration, what happens is we look after the initial administration, and we'll look at that shortly. Then after that, whatever's left over, we then pay specific gifts. And if when we do make a specific gift, for example, a farm, if that has been sold by the testator prior to their death, we've got to make sure whether we have a specific gift or the equivalent market value, because specific gifts are paid first, and then it goes into what we call the residual estate, or the remainder. And what's left over, that then will go down to, as you can see here, the principal beneficiary, which we've talked about, the secondary beneficiary, and then we may have a tertiary beneficiary as well, if all those other people are passed away. Renunciation is an interesting one. You don't see that often in Australia, but it's an important one, because if a client, particularly if it goes from, say, dad to mum or mum to dad, and they're both over age pension age, that gift may have quite a significant impact for Social Security. So in that instance, the beneficiary can renounce their entitlement, and that will obviously, benefit won't go into the main or principal beneficiary. If they are that, then they go down to the next level. So that's, again, executor needs to be in that position of knowing what a renunciation is. The testamentary trust, which I'm all sure you've heard of, but this is a really important one. It's a trust that's established out of the will by the executor, and it may hold a specific gift or part or whole the residual or the remainder estate for beneficiaries. Now, for example, it may be that, as we saw before, that mum gets, 50%, the remaining 50% is to be split to 3 children, and they're each to take the benefit via a testamentary trust. Question there is, do you build a single testamentary trust or multiple one? And Tony will look at that a little bit later on. One of the key issues around that testamentary trust, and I've seen it a number of times when it comes around to drafting up the will, some of the larger legal firms will actually build a whole testamentary trust, which is, we'll look at the reasoning why we have a discretionary testamentary trust a little bit later on as opposed to a fixed trust. But they'll build it with all the whole testamentary trust documents intact. Now, the fact that it's actually sitting inside the will means nothing, because you can't actually set up a testamentary trust until post-probate, and the executor settles that trust, which is absolutely crucial. So all the paperwork that they're putting in there is just really to bulk out the will and the document. It can be quite confusing. It can also be unnecessarily restrictive, because if you put something in that's 10 years ago, you might find there's been quite different changes. For example, there was recent changes to Section 102AG for testamentary trusts, which effectively created some anti-avoidance rules around that, whereas old documentation that may be in place may be defunct. So it's better to put in, and you'll see that through the Lightyear Docs platform, or certainly the way that Abbott Mourly work is, it's better off to put in some generalities around the testamentary trust, and then on death, effectively, then that testamentary trust is created post-probate and is settled. In fact, we just did one recently on that one. Do you want to go through that, Tony, just as to the practical application of what happened in terms of that client?
Which one was that? Sorry, I just got cut out.
Sorry, in terms of Kirby.
Oh, right. Okay. Yeah. So what happened was we did Mr. Kirby will back in March, basically, and what had happened was he eventually passed away, and then what had happened was what we needed to do is create, according to his will, he wanted to create 2 trusts, basically. And we're in the process now, basically, of creating a testamentary trust for one of the kids. And we're doing, and we're running it through basically what's called a family protection trust, which is more appropriate, which has got the same income, the stream provisions, all that type of stuff. But what it does is basically it shuts out, and there's some amendments that have been done to customise and tailor this testamentary trust also. So what it does is basically it excludes, because he wants it for the protection of his children and his DNA or lineage, so to speak. So there were some amendments that were made to that, excluding certain classes of beneficiaries, basically. So
which is perfect, because you can get those instructions and put them into the testamentary trust. And then obviously when it comes round to the estate, which is, again, it's important for you as accountants and also financial planners, and we were dealing with a financial planner in this instance, to ensure that effectively you're in that position to create that, and then obviously work with us at Abbott Mourly to ensure that it meets the goals and the entitlements of the client, which is absolutely fantastic.
Yeah.
Yep, go on.
No, I'm just saying, yeah. So this is the key, Grant, at the end of the day. This is what's important for accountants and planners. You know, if you haven't got, if you haven't got, the accountant and planner working in with a lawyer or with AM at the end of the day, you won't be able to achieve the goals of the client's needs at the end of the day, what his requirements are. The accountant holds, what does he hold? He holds financials and, all that type of stuff for his businesses, and, he does all that. And the planner, what does the planner do at the end of the day, Grant?
Well, I mean, if you have a look at it, the planner and the accountant, they know the client, and I think
They
that's
know it.
that's a crucial part of the whole equation.
Exactly.
So
So the
you go on.
so the exchange of information between the accountant and the planner goes back to AM at the end of the day. In order to prepare what? In order to prepare an effective plan or an estate plan for the client's needs at the end of the day, because you
So
can
the
follow
accountant and
that.
the planner will get involved in the whole process, and we'll show you a little bit later on. They'll build it through the Lightyear Docs platform. But I know Michael. Michael, are you there at all? Or
I am, Grant.
yeah, I mean, you've gone through this process yourself with some of your clients, and I know you've had a look at it and you've used the Lightyear Docs. You've obviously done it quite successfully. What are you finding?
I'm finding it really good, and certainly working in with Abbott and Mourly helps a lot. And the Lightyear Doc products are just fantastic in terms of providing, I guess, that protection and certainty on what's going to happen. I've mentioned to you and had discussions where I was a little while back an executor on a client's estate where there wasn't that certainty or protection, and it got attacked from all sides. And it wasn't.
How long did that take to resolve?
A good 18 months.
Yeah, and how stressful was it?
Very stressful. Number of legal fees. It was getting attacked from stepchildren and everyone that could.
And you were the executor?
I was with.
Yeah, I know. Probably won't be an executor again, but they love to take pot shots at the executor, don't they?
They do, and yeah, it's quite an interesting process. But certainly, the products that Lightyear have got and what you and Tony have worked on and put together are just absolutely fantastic in relation to ensuring that their wishes are met of your clients. And I agree 100%. The accountant and the planner knows the client inside and out, and can work in building that that client needs, and I guess that data collection, and then filling it out using the Lightyear documents, and then they have the ability to use Abbott and Mourly in more complex matters, or if they would like that additional I guess certainty as well.
I mean, you've obviously gone through both processes. One is obviously going to a lawyer and it being challenged versus building it from scratch yourself and doing it for clients. Which do you find better in the long term?
I mean, I find it better doing it myself, but there certainly are different clients that require additional, I guess, provide me with additional comfort where I can speak to Tony or yourself in relation to those. I guess it depends on how simple and complex the matter is. But I mean, I've certainly used our product for what I would call reasonably complex client positions. So, and I find the process easy to use. But I mean, it's important that you understand the documents and what you're actually providing to the client as well when you're going through that collection process.
Yeah, which is one of the reasons that we're doing obviously this training with you to make sure that you're well and truly on top of it. Because at the end of the day, I'll get Tony to come in, and Tony's talked about this quite a bit. Obviously, one of the major concerns for a lot of accountants and also planners is, am I providing legal advice? Where do I stand? So, Tony, you just want to cover this again, just to give people a heads up.
It's a bit of a grey area where I guess accountants and planners are concerned, aren't they?
Yeah,
absolutely, Mike. Yeah, for sure. Yeah. So these are some of the key features key features in relation to actions that are legal services and for the provision of legal advice, such as drawing and drafting documents of a legal nature. That's our job. Giving legal advice. That's our job. Appearing in court. That's our job. And drafting a will from scratch, okay, from the very start, or using the name of a barrister, solicitor, or an Australian legal practitioner, or another name used to describe someone who is qualified to engage in legal practice.
Which is what I was telling everyone before. So in fact, I'm probably pretty instructive of where everyone fits. Is that I've drafted. In fact, I've drafted a lot of documents, and I've drafted a lot of wills and testamentary trusts from scratch. Now, from that perspective, is because I'm not a solicitor, I can't go and give that. So what I do is I hand it over to you, you review it, and then you'll effectively provide that legal service to the client.
Well, that's the way it is. I mean,
Exactly.
you know, anybody can draft legal documents. I mean, it doesn't say you can't, but you can't purport to act as a lawyer at the end of the day because you're not, you know.
Okay. Yeah.
So
I think that leads
you
us
can
on
draft and yeah, exactly. So that way, you know, the document comes to me, I review it, you know, I make some amendments or adjustments to it as required by the client, and that way I provide that legal service and that legal sign off, as we say.
Yeah,
So
the legal
everybody's happy.
advice. Yeah.
Exactly. You know.
So I think
So
that's
these
important.
are the.
So do you want to carry on now? What is not a legal service, for example?
Yeah. So what's not legal services or legal advice is basically undertaking work in association with a law firm will not necessarily constitute engaging in legal practice, right? Examples of this: clerical, administrative tasks, as inserting parties' names into a document, because the document's already been drafted, right?
Yep.
Preparing wills from a data capture sheet. You're not really preparing a will. What you're doing is you're obtaining the data capture from the client. That's the information, the data capture. And then what you're effectively doing, inserting that data capture information into the square boxes that it asks you, you know? So, and then it spits out the will because the will's already been drafted in any case. So there may be tweaks, adjustments, you know, as required, but you're not preparing wills or anything like that. So, I mean, all you're doing is just assisting, basically. Not even that. You're providing clerical and administrative tasks. That's what you're doing.
Which is again, I was talking about. It's the same as why a paralegal doesn't need to be a solicitor. And essentially,
and,
like your docs, we've spent a lot of time on that estate planning solution. So that effectively it's perfect for you.
Selling of legal documents, certainly not providing legal services. You're just selling a document. Advising of incidental legal requirements by a person in the pursuit of occupation other than law. Tax agents can give tax advice. That's a requirement. Okay, you're allowed to do that. All right. But if you want specific tax advice, well, then, you know, you can engage a lawyer at the end of the day. So, advising on the requirements of tax legislation. So, if you're a registered tax agent, yeah, sure, you can provide tax advice to your clients. It's not a problem, you know. So,
just fine. So the end result is, Gavin, I know you've got a question on when to use a testamentary trust, which we'll start to look through the basics of the will and the planning process now. But I wanted to do is have a look at a case study, and then from that we can have a chat about what we would do with the client. So what I've got there is, again, we've got John Smith has a house which is jointly owned with his wife, Sally Smith. John's got $200,000 in share investments in his own name, and $550,000 in a super fund pension, which has a reversion to Sally. So that's perfect. He's got a commercial property, which is in his own name, that was previously negatively geared, but now it's positively geared. and then that commercial property is used by his son in the spray painting business. So it's his way of helping out his son. His son Max is 40. Obviously, he's the favoured child there, and essentially he wants to give Max that property outright, and again, it's valued at 500. And then the two daughters are going to split the $200,000 in share investments. Sally's obviously going to get the house and also the pension, so that if John dies, then the title of the house will then go to Sally. So again, it's an important area that when you are doing these wills for your clients, and you'll see that through the Lightyear Docs platform, that you can do joint wills. So you can do one for mum and also for dad. And ultimately, if we go down this track here and we have a look at this whole case study, I would put it to you as an accountant or planner. Essentially, it's worthwhile doing certainly wills and EPOAs for the whole family going down the track. I think that's pretty crucial. So now, if Sally dies, is not alive, in terms of the pension, it's actually to go to Max's disabled child, William. So that's a separate thing. That's not done through the estate. That will be done through superannuation potentially. Of course, if it's been planned for. Otherwise, it will end up in the estate. Now, if one of the children dies, so that's, again, if we've got Max or the other children, Sarah and Jodie die, their children are to get the benefits. But if they don't have children, then it's just to be split proportionally to those other beneficiaries. So if you have a look at it, if we have a broad look at the whole schematic there before we get into the details, I'll just give you my overall point of view as to how it all fits in. And this is one of the differences for you as accountants and financial planners in completing this sort of information, is that not everything goes to the estate. So, for example, here we've got John is jointly owned a property with Sally. And that's the case for about 99% of properties in Australia. And the element there that we're looking at is that when you have got that, then on death, it automatically just transfers to Sally Smith. If you buy a property through a couple, in all jurisdictions, it's deemed to be jointly unless you ensure that it's tenants in common. Now, tenants in common would be completely different, because then you'd have to look after it through the will. So we can sort of put the property aside. The share investments, the money in the SMSF, effectively that's something that will be looked after in the SMSF. We've got a pension there, but we still need to work out, well, does that go over to our superannuation estate? Does it go over to our legal estate or not? And I'm going to cover that a little bit later on. We've got a specific gift there. So we've got a commercial property that he wants to go to Max. Now, if he puts it into the general primary beneficiaries, then you're going to get caught. So what we do there is we've got a specific gift that you'd have a look at there. We'll talk about that a little bit later on. The issue there for Gavin, that if we did do a specific gift there for Max, given that he's got a disabled child and he's got children who are under age 18, I would probably recommend a testamentary trust there for that instance. If they didn't have children and it's just Max, Jodie and Sarah, then you may just well not worry about a testamentary trust. But we'll cover through the 5 or 6 reasons why when we use a testamentary trust a little bit later on. So if we then go, as we said, the pension side is covered quite separately, and then there's a potential of putting testamentary trust. And even what I would be doing down the track in terms of if William was to get the benefits, I'd be building a special disability trust for that, which we'll look at a little bit later on for us. So that sort of gives a heads up of in this case study that I can refer to a little bit later on when we come back to it as to the various assets that would be caught up in that particular estate. So let's just move on. This is building an estate plan. It's a flow chart that Tony's built, and this will be part of the pack that we've got for you. So let me just open that up a little bit, and then so we can all see it. Hopefully, there we go. And let me start at the top. If you want to take us through there, Tony. Nice, loud, clear voice, because you know you're
nice and clear.
You're on TV last night, so you're legend. So
yeah, no, that's great. Look, I've tried to make this flow chart, you know, as best as possible so everybody can understand it, you know. So what do you got? You got the will maker who provides those instructions, okay, which is enduring power of attorney, you know, and then you got, you know, whoever the replacement directors are, successor directors. And then, of course, underneath that, you got to select who the executors are going to be and select who the trustees are going to be. Now, the executors trustees can be, you know, one of the same persons, I guess, you know, what usually happens. And then you've got to select, obviously, you know, your first, second, or third leading member to act either jointly or severally. And the reason for that
I think that's pretty important. As we've seen before, is the pain of having a public trustee really crucial to have, as Tony said, that succession plan for executors in place. So that, you know, is it going to be a single executor? Are they going to work jointly? And then really start to work out who it's going to be. And again, we have seen clients, and you would have seen clients who don't have anyone that they trust. As I said before, you can act as executor like Michael, but you know, don't necessarily think that that's the be all and end all, because at the end of the day, it can take a lot of time. It might be better if you're just the person who's the administrator, or not the administrator, the person who's helping the executor. Even if the executor hasn't really got a huge idea, you're there to basically be in that position of helping them. So
that's important. So you got to, you know, you got to select basically your, you know, your leading members at the end of the day. Then from that, once you've done that and you selected your executors, you selected your trustees, you selected your leading members, then it's time to select who your primary beneficiaries are going to be. Obviously, primary beneficiaries are going to be your spouse. That's what usually happens, right? Unless, of course, you've got other primary beneficiaries that are in play, right? So that's really up to the will maker to provide those instructions on the data capture sheet at the end of the day. And then what you got to do is select any specific gifts to be provided to the beneficiaries, right? You know, they may include property, jewelry, personal items of value, etc., right? So it still forms part of lineage. So what if there's no primary beneficiaries are not around? Well, if the will maker passes, then you'll need to determine basically. Then you'll need to determine who will receive, in what proportions the secondary beneficiary will receive, which is the balance of the estate. Now, it might be 1/3, it may be 10% each, etc., right? It just depends on what the will maker's instructions are at the time. Do you want to add to that, Grant, at all?
Yeah, no, I think it's pretty important. What I might do is I might just let's go through this whole thing, and then we might go to the data capture so that people understand how it can be done in practice.
Yeah. So what happens? You got the adults, B1, B2, B3, who's a minor. We need to determine if there's a minor. Obviously, we need to determine, well, who the guardian's going to be of this kid at the end of the day, right? There may be several guardians, right? Mum and dad's not around. And then what you've got to determine is basically, will it pass through the estate, or will it pass via the beneficiaries at the end of the day? So what's more tax and commercial advantageous in this instance? So what you got to do before anything happens is you got to get it's subject to commercial and tax advice on the passing of the will maker, right? You got to do that, right? To make sure, because you haven't got exactly a crystal ball in your hand what's going to happen in 3 years or 5 years time, or even 12 months time, because laws do change, trusts change, other regulations come into play. So it may not at the time be feasible, depending on the amount of the estate, to pass it, through a testamentary trust, but rather pass it through the estate. You follow?
Yep,
So that's just, you have to do that. So before you do anything, when the passing of the will maker, make sure you've got a copy of that will. You go to a solicitor and you say, can you please provide me some commercial and tax advice around this will, as there's X amount of assets basically in the will, and we want to make sure that it provides for proper commercial and tax advice at the end of it. So
and like, if you're an accountant already and you're a tax agent,
yeah,
then you can give the tax advice. That's part of the whole purpose of the gig. So I think that's absolutely crucial what Tony was saying. So we set it up, and obviously the big tax advice that no doubt you're all looking at is what happens, if we have a testamentary trust and we've got minors. The benefit of a testamentary trust is holding that money aside, as we'll see a little bit later on, but benefiting from adult tax rates. And that also is exactly the same with the special disability trust. So if we do go down that testamentary trust route, which is quite useful for some of our clients, then what we do there, you can see, and I think Lenny just spelt wrong there, Tony, but anyway, that's okay.
Whereabouts? Sorry?
Lenny, I think it's Lineage, but I'm not sure.
Sorry, my apologies for that. I didn't pick up on that one there. Okay, so once we've done that, the tax advice is all good. It says basically, yep, we should set up a testamentary trust. Well, then you set up 3 individual testamentary trusts in relation to those kids. So, and that's where you set up basically what's called, what we've called it, I guess, is a family protection trust or testamentary trust, where you appoint the family protectors, basically, followed by, your second family. Is it it's the second appointer or family protector? Is that right, Grant?
Yeah, definitely. Yeah, so it's
absolutely.
Yeah, so what you're doing is you're building a testamentary trust, and you can also build one straight out of your SMSF as well, which we'll look at a little bit later on. So we'll go through the different trusts. I know a couple of people said that the sound is breaking up. It's not breaking up at our end, so it may well be your connection. But importantly, as I said, it'll all be recorded, so you're going to understand everything that goes on there, which is crucial for us. So let's go back and have a look at where we're at. We've gone and Tony's got a flow chart there, which is absolutely fantastic. So that gives us a really good understanding. Now, with the executor's role, which is absolutely crucial, as I said before, you need to make just not one executor, but make a succession of executors. The executor's role is essentially going to administer the estate. So the first thing they're going to do is locate the will, and that's absolutely crucial. As Tony said, I personally, I think it's important to have 3 copies at least. One which can be held by Abbott Mourly, which is a certified copy, and that really does make a huge difference when it comes around to probate, etc. That can be held at the Abbott Mourly offices. You hold one. Remember, you're building a lot of this estate planning yourself. Hold one in your offices, and then obviously give one to the client as well. So the first one is obviously locating the will, arranging the funeral. That may well be if the executor is not the family member. It may be the family members organise it, but the expenses for the funeral can be paid out of the estate. The next step is obviously obtaining probate, which Tony went through before, ascertaining assets and liabilities, and then discharging the liabilities. So, for example, for those of you who have been using the protector The protector is where, for example, if I use the protector, I back up here, I may well have the protector in place, not for the, I may well have the protector in place for both John and also Sally's equity there if I wanted to. But because it's jointly owned, there's an issue whether I want to do that. I probably would, but we'll just take that out of the side. But certainly the $200,000 and the 550 for, the $200,000 and the 500 in relation to those properties of $700,000. That's obviously exposed from litigation if it's in his own name. So what we can do is we can build a protector, give that $700,000, which represents a property and also share investments over into family protection trust, which Tony was talking about. The key about a family protection trust is you have a family protection appointor, whoever really looks after that trust. They may be designated as the trustee. On death, obviously, that loan, so the money's been gifted over and lent back to John. So when we come around to it, it's quite interesting, and let's have a look at this. One of the key roles of the executor is to discharge the liabilities of John Smith in this case. So one of the liabilities there will be the trustee of the Family Protection Trust has a loan to John Smith, which is obviously you'd want to do a registered mortgage over the property and PPSR over the share investments. So that in the event of John's death, what will happen is the trustee of the Family Protection Trust, which may well be the executor of the estate, will call upon that loan. Now, interestingly, you can see there that asset protection mechanism, that liability, because you're paying taxes, you're paying funeral expenses, any other expenses. Importantly, from that perspective, is the loan will now pull out of the estate $700,000, and that will now go into a family provisions trust. And so before there was a gift and a loan back, now what will happen is that loan will be extinguished, and effectively the Family Protection Trust will have $700,000 in cash, or alternatively those assets could be transferred in subject to stamps and obviously capital gains tax at that point in time, which will be okay. Obviously, we've just got to be careful about that and which jurisdiction it is. But at the end of the day, the will you've done, if you can see there, that asset protection mechanism that we're building in place there, effectively what we have done is essentially shrunk the estate to virtually zero. Now, the reason we're doing that, I don't want to get you conflicted around that, but where there's a potential family provisions claim, we may end up using that protected trust, which is crucial. So just remember, this is where the liabilities come. Now, at the end of the day, there's going to be a set dollar amount, which the executor will have to prepare a distribution report for the beneficiaries. Remember, the first person to receive it is obviously going to be the beneficiaries who are receiving the specific gifts. When you create the will, it is absolutely crucial to work out, and you'll see this in our documentation, whether the executor is to pay for any taxes and expenses for the transfer of a specific gift, such as a property, a car, etc., or is it to be paid by the beneficiary? Because that can make a huge difference to the remainder of the estate. So we look at the specific gifts, look at the remainder, who's going to pay the taxes, and then that will give a distribution report, and the executor is essentially up and running on that one. So let's just go through. I'm going to bounce out of here just pretty quickly, and I just want to go into something for you so you can see. Now, this is available to all of you. You can see here. So this is Introduction to Wills training on July the 7th, which is great. But I'm in our support centre. So you've all got access to our support centre, client emails, data capture, and letters of advice. So you will see here, what we've got here is a a new one, client data capture for enduring power of attorney, will and SMSF will. So if we have a look at this, essentially this is the start of the data capture, but the following interview for your enduring power of attorney, will and SMSF will captures details around who will be looking after your affairs in the event of your incapacity or on your death. It looks at whether you want to leave any specific gifts to anyone, and finally, who and what percentages of the estate you would like to leave to one or more of your primary beneficiaries. Also, for completeness, if they are not alive, what is to happen to their share, such as being redistributed to remaining beneficiaries, primary, what would be passed on to secondary beneficiary if there's only one primary beneficiary, such as a spouse, and they are not alive at the time of your death. The interview also includes whether you have any funeral wishes, what may happen to digital assets such as Bitcoin or Facebook, if you have children under 18 or pets, who is to be their guardian, and if you own a property and want your spouse or some other person to live in the property for their life, known as a life interest. If you have a self-managed superannuation fund, you'll also be able to leave instructions you would like your super benefits paid in the event of your death. Your will cannot designate at law what happens to your super benefits. This is the purpose of the SMSF will. If you have any questions, please don't hesitate to contact us, and we look forward to receiving the following information as soon as possible so we can complete the relevant documents based on interview data capture. So you can then just copy and paste that to your client and then send it off. So if you talk to them about doing an estate plan, the ability for you to do an estate plan, then copy and paste that. Then what will happen is you'll get this data capture. And remember, Tony went through quite a bit of detail around the importance of the data capture. So this will just pop up here, send that out directly to the client, and you can see here that we've got interview and data capture, enduring power of attorney, will and SMSF will. You can see all the wording I just covered there. The following interview, blah, 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 is all covered there anyway. Now, you can either send this data capture out, but I'll put in here, it's a Word thing. Alternatively, this is from you, remember, we can complete the interview, data capture by way of a Zoom meeting. Please contact us to arrange this meeting. So essentially, the way it's to be completed, it's very easy. To make life easy, you can put into this table all those persons who may be part of your enduring power of attorney, estate, including executors, family members, beneficiaries, and any other person. So you put in the name, relationship to you, and the address. And this is important because this follows exactly how our light year docs will, or light year docs will with testamentary trust follows. So then we go down, and remember this idea of succession executors, which is where we're talking about now. So who is to be your enduring power of attorney and executor? Put their name in the box below, as you will have put their address and relationship to you in the common pays above. This may be held jointly by one or more persons. If you want different persons for the roles, write in the box below the name of those persons, but for simplicity and safety, it's best to have one person or persons being your enduring power of attorney and executor. So this means that we're driving into doing both an EPOA and a will for your client. So you put down the first level who the executors are. Now, if none of your EPOAs or executors can fulfill their duties because of sickness, incapacity, death, who's to be your second in line? We call that the successor executor. And we've got the third one. So again, it goes back to what Tony was saying, is we've got our first line, our second line, and our third line. Because it's absolutely crucial to get this line of executors right. And more importantly, from that perspective, that executor may well be, as Tony showed you in the flowchart, the leading member of any discretionary trust we have, or a leading member of any SMSF we have, and also may well be that family protection appointor of a family protection trust. So we want to start to build it all in to get, we want to get that certainty and security and make sure it's safe. This is part of that planning process that generally a lawyer won't do, because a lawyer won't have that succession in terms of the appointor in any family protection trust, and certainly won't have succession planning in terms of a self-managed superannuation fund. So we move beyond there, and that's that succession piece. We go down a little bit later on, and you can see here we've got our enduring powers of attorney, which I won't go into any detail. Successor directors, this is absolutely crucial. It's a whole separate set of estate planning. I'm doing a session on this tomorrow where we're rolling that out, successor directors, but essentially in the event, you want to make sure that any company that your client has, for example, probably not John Smith, But if I was looking at Max Smith, and this is why it's important to do family wills and EPOAs, in the event that Max passes away or becomes disabled or incapacitated, particularly if you've got a spray painting business, you know, you're only a heartbeat away from a disaster happening. If he's the sole director of the company, who's actually going to go on and run that company? And it may well be that John Smith is going to be the successor director for Max. And so what we want to do is put down the company name and also the successor directors. So you can insert that, but that's quite a separate document in itself. Make sure that you have a look at that. This is probably, of all the company stuff in Australia, and there's, I think, gosh, I forget how many companies are. There's, you know, hundreds of thousands of them. None of them have successor directors. So I'll be covering our solution tomorrow around successor directors. So make sure you turn up to 11 o'clock session. So we've gone past successor directors. We're now going to wills and specific gifts. So here, after appointing a chain of executors to manage your estate, the next step is to guide your executor with your desire to make a specific gift to a spouse, child, grandchild, or other person. Once this is done and the gifts are made, anything left over forms the remaining estate, which may be passed in its entirety to a spouse or children will be individually to be shared. Importantly, specific gifts rank higher in importance than the remaining estate, so spend times on the specifics. So this is what we've just been training ourselves on. The first step then is to look at specific gifts. Now, do you want to make any specific gift to any person, such as my investment property, 5 Smith Street, Collingwood, is to go equally to my eldest daughter, Jane, and son, Mark. So when we go through those specific gifts, we need to work those ones out. Feel free to make as many bequests or gifts as you want. And then we got specific gifts. This provides your executor with the authority to transfer property, so on and so forth. So again, your client can then put down any specific gifts there. And up here we've got, for example, it could be that my executors distribute my personal effects and jewellery in a fair and reasonable manner. So we've got everything that's sort of catered in for. You can even see down here, we've even covered digital assets and crypto, such as Bitcoin. So we're very much in the time, because the more that we get down on that data capture, and you certainly, I'm sure many of you have seen data captures from lawyers, you're certainly not going to get that information there. But you pull all this information in, and then it's very easy to pull that data capture into our system. Now, wills in your remaining estate. If there are any assets or monies left over, after paying all the expenses of the estate and also paying out all specific gifts, the remaining estate called the residual estate to pass to the main beneficiary. So the first one, who's the main beneficiary? Now, this is important. Again, this follows on directly into our system. If the main beneficiary is not alive, who is to get their benefits? Choose from one of the following. So, is it to be their bloodline children, which may be held on trust subject to the executor's discretion on the advice of the advisor of the estate? Now, for John, obviously, if his main beneficiary here is going to be Sally, and she's to get 100% of the, sorry, if we have a look at it, we're going to get Max, who's actually going to get the specific gift up here. If Max is not alive, then where's their benefit going to go? Now, for this one, this is for the main beneficiaries. For specific gifts, it's the same. It can go to his bloodline children because he's got a couple of young ones, which is important. Or it could go to any surviving main beneficiary in equal proportions. It could be paid to secondary beneficiaries, which might be Jody and Sarah in that instance, or could be paid to any bloodline beneficiary at the executor's discretion. Bloodline beneficiary, as Tony pointed out right down the bottom of that flow chart, that can include cousins, second cousin. As long as they share your DNA, they're classified as bloodline beneficiary. Now, for that one, if we've chosen secondary beneficiary, then we go down the track, we build a secondary beneficiary, and then go down for this one as well, to pay any secondary beneficiary. I haven't put tertiary in there because I don't want to get it too confusing or too long. What are your funeral wishes? That's pretty obvious. Child and pet guardianship. If you have children or pets, who is to be their guardian? Please identify specifically with the name of the guardian any financial provision of being made to them. So the name of the child, name of the guardian, second guardian if the first is not able to live, pet guardianship. Life tenancy. So where we had Sally and John, that was jointly owned. But if the asset was owned 100% by, for example, John, he may well give Sally a specific life interest in that property. with at the end of the day, that creates a life interest trust or a life trust. So at the end of the day, the beneficiaries of that life trust will receive the benefit of that property. And that may well be, for example, in this instance, Max and Jody as well, and Sarah. When we go down the SMSF will, I won't go into that one, but there's quite a lot of detail in relation to how that works there. But as you can see, it's quite it's a bit different from the typical data capture you'll see with a lawyer, which goes heavily into assets, structures, and all that. What we've done down here is more about purpose. It's about how the percentages, how the breakdowns are, how to get that succession planning in there. So that interview and data capture is, as I said before, that's available up on this client data capture, which you'll find in here in that section, the client emails, data capture, and letters of advice. I've got up here, for example, email copy, rules and enduring powers of attorney. I will be building, in addition, an email that you can send out to clients on a general perspective around all of this, and that will be up very shortly. Now notice here, you've got enduring power of attorney, will and letter with data capture. This one actually covers the SMSF will and is a more modern one on top of that. So let's just jump back into the slides. I just wanted to take us from here. We've built the plan, we've built the flow chart, we've sent the data capture out to the client, and then we now start to move on. So we've talked about the executive's role, which is absolutely crucial. Now, what will happen is in some instances with clients, for example, where we've got the idea, we understand around special disability trusts. They're obviously not available on the Lightyear Docs platform. Successor directors doing all that. Now, if we have our basic wills and EPOAs, for example, if it's just going straight from John to Sally and that's it, so there's no secondary beneficiaries, which is quite typical, then you may be able to, you can do that on the platform, and you can go, for example, as Tony said, it could go, for example, to Sally, and then secondary beneficiaries to be split to obviously Sally, Jody, and also Max in equal proportions, which is not the case in these circumstances. If that's the case, so it's only virtually a very short will, then essentially you can prepare that on the Lightyear Docs platform. Again, you're simply going through that data capture, and then when that happens, you can prepare it, send it out to the client for a draft review, bring it back, and then if need be, if there's any changes you can make on top of that. However, we do find that a number of our accountants and financial planners, particularly where, for example, we've got disabled children or we've got different payments going out, they prefer to get legal advice from Abbott Mourly. So there's a 5-step process for that, and Tony will just take you through that now.
Yeah, with this 5-step process, it's pretty easy. It's not that hard, So all you got to do is just, like I said initially, you got to prepare up the data capture. After you've prepared the data capture, you insert all the fields within the will via the Lightyear platform. It will then generate a will for you, or an EPOA in combination. It'll spit out the will basically, and then there's 2 ways. If the client wants no legal advice, that is no legal advice, then the client, you'll get an actual letter in the way how wills are executed, right?
We'll talk about that very shortly.
Yeah. So, but having said that, if the client, however, wants the provision of legal services, this is where we step in step 3, 4, and 5, basically. Okay. So the will is then, if we come up to step 3, then what will happen is the advisor will give me the draft documents that have been prepared.
Actually, can we just stop there? I think that's pretty important for all of you to understand.
Okay.
Is that you've sat down, you're doing the planning with the client, you've sent the data capture on, you've actually put that data capture material, which I'm going to show you in a second, into the system. And then either, as Tony said, if the client, and this is important, it's the client's choice. If the client wants to go and see a solicitor, get legal advice, then essentially it's going to be an additional $495 payable to Abbott Mourly for the service, which Tony will talk about. Alternatively, if they don't, then they can just go ahead and do the documents themselves. But if they do want to get that extra service, as we said, you've prepared all the documents, you're obviously going to charge a fee for that, which is why, really, because through this process, Tony will tell you about, it takes them 3.5 hours, all up, all told, is that in essence, there's still a lot of, you'll charge a fee. For example, if you're doing an enduring power of attorney, you're doing a simple will for the client, you'll probably charge a fee of maybe $700 for that one as well. And if it's a couple, you might charge $1,200, and then the Abbott Mourly fee will be on top of that. But if you've got a testamentary trust, then you won't be charging those low fees. You'll probably be charging $2,500 with testamentary trust, but our Abbott Mourly fee is exactly the same. So again, the whole idea there is, if there's a testamentary trust, I'm going to show you when you would put that in play, then it's going to be up to the client to make that decision for you. But once we get the documents back for you, you've obviously worked out the tax side of things, all of that we went through before. Then all those documents are then sent over to Tony, and then effectively he'll now take you up from step 3 and beyond.
And beyond, then we set up the Zoom. That's the first Zoom, obviously, between the client advisor and myself. We'll run through the will, make sure that what's been said as per the client's instructions, divvy up. If not, then the documents are sent back to me again, and then I make the necessary amendments to the will or the EPOA. And then step 5, then we come back for a second Zoom with the client to make sure that those amendments are correct, which 99.99% is all okay. And then we take it to finalisation, which is the execution and witnessing stage, basically via Zoom, because we're allowed to do that, right? So that's step 3, 4, and 5. Basically, that's where we essentially get involved with the provision of legal services on these documents, and it's always worthwhile to do that, as opposed to just saying no, I don't want any legal advice. I mean, that's just insane.
So what I'll do is I'll just show you one. I think I've got a copy. I'm just going to go into my document storage. I'll show you one. I'm not going to spend time going through this. There's plenty of videos on that one. I'm just going to go to Abbott Test. I'll show you one. Here we go, EPOA and will automation. So this is not a testamentary trust, it's just a straight will. But I just want to show you a couple of things again, how you prepare it. You've got your data capture here, and we'll have a look through there. So remember, we've got our common parties. We've got John and Jane. Unfortunately, these are different names. But I prepared that. But you've put in the common parties. Remember, that's part of that data capture we've done. You've got common addresses, which can be poked up they'll picked up. Now, the documents, you can do your enduring power of attorney. Do you want to complete a basic will? Yes. And now, this is an important one. Are you an accountant, financial planner, or estate planning advisor preparing this document from a client's data capture? Now, that is important that you tick that, because then there's a disclaimer that you're not providing legal services. So you'll simply put in the yes, put in the date of the client's data capture. If you don't know, you don't worry about it, and then put in your firm's name. I'll jump past the enduring power of attorney, and let's just go up to, let's go straight to your estate. So we're now making a last will and testament. As I said before, with all our documents, you can do documents not only for your main client, but also for the spouse while you're there. So that'll include a spouse will and also EPOA. So you pull the data from your data capture. Who's the testator? So obviously John Smith. And again, appointing a professional advisor. Remember, we talked about that. To make things smooth and efficient when a person passes, it's important to have a professional accounting firm, financial planning lawyer to manage the process of implementing any testamentary trust, so on and so forth. So you put your firm's name in there because it's part of John's wishes that you are going to be the advisor to the executor, which is crucial. Now we work out the executor. So in this instance, we had Jane Smith. I'm just going to change this, just show you how flexible our system is. I'm going to change this to Sally Smith. And then you'll see here, when I come down to the testator, come down to the executor and see I've chosen Sally Smith. But I'll go back up here. I'm going to change this to Max so you understand it's exactly the same. So I'm down here and I've got the executor, Sally and Max. Now notice how they're joint, and more importantly, Max is an overseas executor. So we might not want to do that because I've got the successor executor there being Mum Smith. We might in fact probably, given the fact that he's overseas, we may decide to get rid of Max. And to do that, you'll just see up on our system, see the right-hand corner, there's this little button, never go erase all answers, just delete the repetition. And so there we go, that Max is gone. Successor executor, I've got Mum Smith. But remember, Mum mightn't have a huge amount of financial information, but that is why it's important that you are there to support Mum along the way and make that decision. So second successor, I've got Sarah, but let's make it Max. And so we just put Max Smith in there. Third successor, I've gone, well, no, well, let's go yes. And then we might make that Sarah Smith. So again, we've got a good, strong line chain of executors. And all of this, you don't make those choices. They come from, they obviously come from the data capture. But when you send the final product back to the client, you'll say, look, is this the right chain of events? Max is overseas, maybe he should be the second or the third successor, etc. Specific gifts, is there specific gifts? Yes. And you can see here, we've got jewelry that is going out to the estate. We've got there, Sarah Smith is going to get the Jaguar car. Jim Smith, who's the brother, as male, is going to get farming property. Actually, that should have been Max. So I was going to get the farming property. So obviously it just doesn't go down to that level. The principal beneficiary is Sally. She's going to get 100%. If she's not around, it's to be paid to any bloodline beneficiary. The secondary beneficiary, we haven't got one. Alternatively, we could do the principal beneficiary being Sally Smith to be paid to the secondary beneficiary. And then when I come down here, is there a second beneficiary? I go, yes, we've got Mum Smith. And then that's it. So if we do that, so we're going to get the 50%. So what we can do is we can basically complete all that. What I want to do is just show you basically, it's not a fully completed version. As you can see, I've got quite a few things to adjust, but I just wanted to show you that letter that Tony was talking about, which is absolutely crucial from your perspective and also for your clients. So because we picked that, that button, there's two letters of advice that come from Abbott Mourly, which are included as part of your pack. And so we just want to go and have a look at those. You can see the last will and testament and enduring power of attorney. We've got the EPOA in Queensland. Now, this is the first letter of advice. You've got the attached will and EPOA is based on the data capture form completed with you by Smith Accountants. It uses current legal precedents provided by a legal firm, Abbott Mourly, to look after you in the following manner. Who and how a person you choose as your attorney will look after your personal health, financial and superannuation affairs in the event that you're sick, quarantined in hospital, etc. So that's your EPOA. Or who and how your personal effects, assets and property will be legally gifted and transferred upon your death in your will. Now, this is where this isn't really important for you. It's important that you read the following, as the legal nature extends beyond the data capture and administrative processing completed by Smith Accountants who are not solicited, do not hold themselves out as such. However, your advisor, expert in estate planning matters, including taxation, asset protection, succession, ensuring where required, the estate is limited to deceased, bloodline, or lineage. What documents are attached? You've got your enduring power of attorney. You've also got your will, who's to be your executor, who's going to get specific gifts, all that stuff that we talked about, which they would have got it from their data capture anyway. Now, this is where important, and certainly this is the If we have a look at wills can be challenged in the Supreme Court by any eligible person, including children, grandchildren, ex-spouses, and others. There's been a recent challenge where a friend got up, believe it or not, who feel they've been left out or not adequately provided for. This can delay the transfer of your assets, and with court costs eating into estate and gifts. So if any of the following have occurred or likely occur, please contact Smith Accountants immediately, because we need to provide you with a more protective tailored will, which generally means a testamentary trust. So when would you use a testamentary trust? Are they getting married in the near future? That's not you don't necessarily need to use a testamentary trust, but you need to cater for it. Are you separated but not divorced from your spouse? Then definitely you might need to go and have a look at putting some protection measures in there. Do you have an ex-spouse? Well, they're going to be potentially a family provisions claim. So absolutely, you probably put in testamentary trust there for the children. Do you wish to exclude any family members such as spouse, partner, child, or other dependent? Do you have any beneficiaries have special needs, including mental or physical incapacity, marital problems, bankruptcy issues, or a big spender? Do you own a business or own shares? So if a client comes back and says yes, then we may need to, you may need to get in touch with Abbott Mourly around that. The second one is in terms of the execution. I won't go through this, but it's quite a detailed letter from Tony on how to go about executing your last will and EPOA. And then obviously we get into the legal documents itself. So that's the process. You can prepare that against the fact that you're preparing for a data capture. You can get it up to there. And again, it's up to the client if they want to go and get that legal advice from Abbott Mourly, but otherwise embedded into that, the documents you are preparing is obviously that Abbott and Mourly sign off. So let's go down to a simple testamentary trust that Tony was talking about. Do you just want to go through that simple testamentary trust for people?
Yeah, it's just a very simple one. Well, all it is basically you got the deceased pass away, he's got 100% of the assets, that pass through. You got the estate, the executor handles the estate. 100% of those assets are then distributed via, a simple testamentary trust. Beneficiaries including spouse and children, basically. So we can get into the, the effectiveness of, testamentary trusts and for tax purposes a little bit later on. But that's just a simple, simple plain Jane diagram, basically, you can follow.
So correctly building a testamentary trust. So when we have a look at the trustee, it can be a surviving spouse or child, or alternatively, it can be because essentially when you have a look at the trustee and you're building a testamentary trust, ordinarily it's going to be a discretionary trust. So you need to take, and this is really important, to take that knowledge that you've got from asset protection, building trusts, is that we need to then start to work out who the appointor is first. When we look at the appointor, much the same as we did with the executor, in order to provide a solid base for it, we need to have a succession. So who's the first appointor? Who's the second? Who's the third appointor? Now, the person who's the appointor will actually control that testamentary trust. So when you come around to building that testamentary trust, effectively you're going to work out, is it going to be limited to bloodline or not? And essentially, if we have that testamentary trust or that family protection appointor, essentially it's going to be their bloodline who can actually be beneficiaries of the trust and includes any entities that they may be involved with, which is pretty crucial. Now, with a trustee of the trust, you can have your surviving spouse or the child if they're of adult age. But for example, if you've got a 21-year-old daughter like myself, there's no way you'd probably make them the trustee. So it could well be the executor is acting as the trustee of the trust, which is pretty crucial. Again, if flexibility is desired, the trustee will control the gift as if they own the assets of the trust, but will enjoy the protection afforded by the trust. You can restrict the control your spouse or child has over the trust assets. For example, you could use a third party as a trustee, but still retain a discretionary trust. Again, that could be the executor, or it could be, for example, yourself or any other like brother, sister, or even just a friend. But you just got to be careful. They're the trustee. Really, the key dynamic here is who is going to be the appointor. And you may well make, for example, the child who's 21, they can become trustee. You can put notes in there. They can be trustee and appointor once they reach age 25. Now, it will depend if you're building a single trust for each person or an aggregated trust, which we'll have a look at. Or alternatively, which I prefer here, is you could add a third party as a joint trustee. You could add a third party as a joint trustee along with your spouse and child, but still use a discretionary trust. Regardless of who the trustee is, you could restrict access to the capital. For example, we may have, there can be no access to the capital until age 25. But certainly income or percentage of capital can be paid out over a period of time. You can actually put in place a capital protected trust, which is protecting the capital up to a certain age if need be. Or for example, you may not pay out any capital until someone turns age 40, or you could put in conditions that capital is only to be paid out, for example, for the payment of a mortgage of a house or a deposit on a house. So there's a whole lot there. There's other special forms of discretionary trusts that we'll look at a little bit later on. So I've got a question. Does A&M professional indemnity insurance cover the will if legal advice is sought and the cover letter just shown received? Absolutely. So you'll find, Gavin, once that happens, if you do get that legal advice, it's not your PI anymore, because the final documents are actually, although you've done the initial documents, the final documents are prepared by Abbott and Mourly, and also they are protected by legal professional privilege. Again, what we're doing is we're giving you the opportunity there to get that, or your clients to get that legal advice, meet with a solicitor, get it all signed off at that back end. So it really gives you a good option. But we've been very mindful of the fact that traditionally you've been referring clients off to lawyers. They'll charge the fee. You do a lot of work in that process, and effectively you'll get nothing out of it. So that's why we've been very sharp, extremely sharp at that pointy end on our fees for the work that's actually created for that. So again, that's a really good question, Gavin. So the principal advantages of incorporating testamentary trusts into wills. Just want to cover these two, Tony.
Yeah, so the advantages of creating, testamentary trusts is it's designed to provide maximum flexibility and allow for tax effective distribution of capital and income, as well as providing possible protection for the beneficiaries from third parties such as creditors and any other, like any other litigation potentially coming on.
The tax office.
Yeah. So and trusts also allow optimum, allocation of income and capital, which in turn may permit beneficiaries to qualify for aged, disability and sole parent pensions also. So there you go. And also the incorporation of a testamentary trust into a will is not relevant for every situation, which is not, but in many cases they offer valuable advantages over simple wills, basically.
As you can see, I think they're obviously very in vogue with, and look, I would say going down the track, if you think there's going to be a potential issue or one of the kids are going to be a waster or whatever, then have a chat with a client around that one. That's absolutely crucial to build those in. Lawyers definitely do an upsell on testamentary trusts because, for example, a typical a will with an EPOA might charge $700, $800, $900 for, but add a testamentary trust, Tony, what is it? It's about an extra $1,200 to put a testamentary trust in place.
Yeah, absolutely. Which is the family protection trust, really, at the end of the day, but it's called a testamentary trust, so to speak.
Okay, so like any trust, I mean, all of you understand it really in depth, is that a testamentary trust is we prefer to use the discretionary trust. You can put caveats around it, so it ends up being a hybrid trust with some fixed elements there, but essentially you can invest in anything depending on what the powers of the trust are. You can have a limitation on that if the client, doesn't want to enable it to be used for business, etc. You can put that embedded into the testamentary trust requirements. So as I said, usually the beneficiary is trustee of their own trust. Depends on their age and also their circumstances. So in this instance, where you have a look at the, William, the disabled child, there's no way they're going to be a trustee of their own trust, even going down the track. So we'll have to use Max or maybe his brother, Ben, who will be the position of being that trustee and the appointer, etc. So each one is going to be dependent on their circumstances. Again, we could have a third party for that one as well. So there's generally a few restrictions are placed on how the trustee is to manage and maintain those assets. And I think that's key. Again, it just comes back to, what we're looking at, from the perspective of any discretionary trust, but you can put some limitations on it. So planners, in fact, you can have a contract in there that you are the designated financial planner for the investments of that trust. So that's absolutely crucial. Once you leave the assets to a beneficiary by way of this type of trust, the trustee beneficiary will have total control unless restricted through the intervention of a third-party trustee whose consent's required. Again, these are just some of the extra terms and conditions you can put in the trust. It provides, obviously, protection of your assets from beneficiaries from third party, as Tony said, bankruptcy, family breakdown. We'll look at that a little bit later on, because there's a move from family court through Essex and Essex to start to attack family trusts as well. So we can put in place some family trusts, and they have been successful in some instances, but others they haven't as well. Obviously here, asset protection. Do you want to go through that one, Tony?
Yeah, so with asset protection issues for the beneficiaries, in terms of testamentary trusts, in leaving equity in the business or any other assets to the children who may be directors of that business or otherwise exposed to personal liability. It's recommended basically that to make
Maybe if you talk up a bit, Tony.
Yep. You can make provision. You can make provision in the testamentary trust in respect to that. And secondly, wills may provide that individual testamentary trust may be established for each child as primary beneficiaries, if that's the case. This will provide some asset protection for those children at risk in occupations or positions, and may quarantine assets from the jurisdiction of the family court also, right? And then, although the family court has become more inclined to treat, trust assets as assets of the marriage, and while they are unlikely to be required to be transferred to the spouse, they could be included in the value of the matrimonial assets resulting in the spouse receiving, a larger share of the non-trust assets at the end of the day. And there's a case, Essex versus Essex, mate.
Yeah, so essentially you've just got to be careful on the way you set them up. And obviously courts, even, family law courts actually even go through self-managed super funds. So you've just got to be careful. With that one, around a lot of these, if I have like 5 minutes in, I'll show you how our testamentary trust solution works. But a lot of these terms and conditions, in fact, what I'll do is I'll just jump in now quickly. It'll just take me a couple of minutes to show you how it works. So if I just go in here, I'm going to go back into my storage. The one I looked at before, obviously there was a will and EPOA, so it didn't have any, I didn't have a testamentary trust here. Here I've got a Smith will and testamentary trust. I'll boot that up here. Again, it's just in my storage. We've made significant changes. This was done in January, so I might need to make a couple of changes. Hopefully it's completed there. We've got our common parties there. Obviously, I haven't built this in the common parties. What I wanted to show you though is when we get down to the principal beneficiary, let's say that we've got a spouse and it's 100%. 100% of my estate. Now, what I can do there is, if the principal beneficiary is not alive, then I can pay the secondary beneficiary or to bloodline children. So let's say this is Max's wife. Now, I just want to show you, wherever you make a specific gift, For example, here, if I make a specific gift, then essentially, or any of these beneficiaries I've got here, you'll see these little buttons here say, do you want this to go into a testamentary trust? If I do, it goes yes. And then all of these terms and conditions are actually put into the will itself, so that the executor, as Tony alluded to, we're working on one at this present point in time. So you build that discretionary testamentary trust at that time. So let me go through each one of those. So do you want to go into a testamentary trust? If it's someone who hasn't got children, it's just Sally, might say no. So she just gets the benefits. She's not alive. It goes to, for example, to secondary beneficiary. Now, the first one is the beneficiary's share of the estate to be automatically transferred to a testamentary trust? So that'll depend. For example, with Max, if I go back to the slides here, and this is sort of gives you a bit of an idea of how it works in practice. So if I go back to our case study here, I've got Max is 40 and John's favourite child, and John wants to give him the property outright. So in that instance, with Max, and we come down and we have a look at building this. So if it's a specific gift for Max, one is, do you want to go into a testamentary trust? Yes. Why is that? Because he's got 2 young children who can we can do it for a tax perspective, which is great. Plus one's disabled as well. So is the beneficiary share of the estate to be automatically transferred? I'd go no. But if the benefit was going to Ben, who's one of the children, then or we're going to someone who's got a drug or alcohol problem, then I'd choose yes. But here I'm going to choose no. Is the spouse to be included along with the main beneficiary? Well, again, that's something you have to have a chat. For example, if it's a second spouse, and remember, if it's going down the track, if this was Sally who we're looking at here, you might say, well, no, I don't want her spouse to be included in case she gets remarried. So we'll go no there. Do you want the secondary beneficiary bloodline or lineage? So again, this is why it gives it that caveat of that bloodline. So we can make it bloodline or not. Are there any related entities the main beneficiary may have an interest in, such as a trust or company? So again, we can go no, or we can add those as well. Is the main beneficiary the appointor? So for this instance, Max, we could go yes. And then we could put in any terms and conditions. And we're thinking of putting more dot points around that. So for example, no beneficiary to receive any capital or become an appointor or trustee until age 25. Now, I could also make any distribution of capital is for housing purposes only. So if I put that in, that then puts those terms and conditions in which we take into account. The executor will effectively take into account there. And again, I can add other principal beneficiaries, specific gifts, etc. And that's how that testamentary trust is created for us inside that will, which is absolutely crucial. So again, you can have a look at how that fits in. So I generally do it for Max, but if you have a look at for Sarah and Jody, they're only going to get $100,000. So essentially, for their perspective, you wouldn't need to have a testamentary trust. Let them just take that out straight away. So Tony's look at the asset protection side of things there. Now, do you want to just go through here why you would use, for example, multi-trust for different children?
Well, if you've got 3 children, the lawmaker may want basically to create 3 individual testamentary trusts, depending, of course, on the size of his or her estate. So again, very simple. It's pretty easy to follow. You've got the deceased, 100% of those of the assets will go through the estate. The executor will control that. It will then, before it does anything, of course, it'll go and seek, its advice from a commercial and tax perspective to see whether or not we should create these trusts, and if so, then you create basically in accordance with what the will says, your 3 trusts basically for the benefit of those beneficiaries. So you got testamentary trust 1, 2, and 3. It'll have a corporate trustee in place, or the child, let's say, and it'll slot in basically the appropriate property to each testamentary trust. So, and that's really, and that's in practice, that's where the administration of estates come in play, basically by the administration of estate lawyers, basically. Yeah.
And George has done asked a brilliant question that is, for example, we're going down all this testamentary trust and we're building it. But if there's a protector trust which is already in play, such that all the liabilities or all the assets of the estate, there is no assets in the estate, then the testamentary trust is just an overkill. So if you're using the protector, the best thing to do is just do really basic wills, going from mum to dad. If mum's not around, just to the kids, but knowing that really at the end of the day, all those assets are sitting in a family protection trust. And Tony and I have used that on a number of occasions for clients, because at the end, when we get down to it, they want to protect it. And again, the only way we can protect it is by using the protector. So great question, George. Multiple here. Again, what happened there is as Tony said, we've set up a separate testamentary trust for each child. This is generally the case would be, for example, if this estate was a bit bigger, and we've got Jody, Sarah and Max, the 3 kids, quite sizable testamentary trust, which I've seen again and again. Each one of those testamentary trusts you can simply press on a button and then that will create a brand new bequest or gift and or brand new beneficiary, which can also have that testamentary trust. So it's very easy, and we can put all those terms and conditions. For example, we may have there that in Max's testamentary trust, if he has it, then the primary beneficiary has to be his disabled child, if need be. Again, there's a lot of things, and I'll look at special disability in a second. Different outcomes of by incorporating a testamentary trust: protect your wealth from unjust claims and keeping your assets in your bloodline, which is absolutely crucial. So again, have a look at these. We'll send you the slides through there. But there's good asset protection there and keeping it into the bloodline, which is crucial. You saw me build that into our system. And look, both of those ones are really super important for us. If you ask your client, do you want to make sure that your family wealth is protected on your death? Obviously, they're going to say yes. The second one is, do you want to make sure it's only distributed to your bloodline? There's a good chance they're going to say yes. So these are the 2 big ones, I think, when you start building this sort of stuff. Have a look when we send you through the slides, a lot of this copy, because it's a really good go-to guide for you. If you have a look there, do you want to go through some of the tax side there, Tony, just pretty brief?
Yeah, just some outcomes basically for testamentary trusts. One of them is basically, your marginal tax rates for kids, turn kids into adults for tax purposes. So income that is distributed to children under 18 from an ordinary trust is subject to what is termed the kiddie tax. This tax applies at a flat rate of 46.5. That is to a child that does not get the benefit of the tax-free threshold and the graduated marginal tax rates. However, if children are under 18 do qualify for these tax concessions on income that they receive from a testamentary trust, this can potentially save a large amount of tax over the life of the testamentary trust, although care must be taken about how the testamentary trust is administered and how the income distributions to the children are recorded, basically. And of course, you've got the capital gains tax and the stamp duty flexibility also in that instance. So when you die and the asset passes directly to one of your beneficiaries, a transfer of all or part of that asset to another person will trigger CGT and stamps for the beneficiary. This is because the beneficiary has a fixed interest in the assets from the time of the will maker's death. And it just gives you a nice little example down the bottom of that. So yeah, there's some different outcomes by incorporating testamentary trusts, the do's and the don'ts, I guess.
Yeah, so there's also a good question here from someone just saying, the protector is about transferring the unrealised equity and assets in the trust by a gift. Main issue, you need the cash to do so. Essentially, that's not correct. So the first thing is it's not the unrealized equity, it's our net equity in assets. So for example, if we've got that commercial property, it's the whole $550,000 that would go over. Now, you're quite right, we haven't got the cash to do that, but what we do is part of the protector, and what I will do is when we send this out, we'll send out a bit of a video on the protector. The cash is actually covered by a promissory note. So it's covered by a promissory note to enable it to build up the equity inside that family provisions trust in order to make that loan going out. We've talked about this before. You can give it to child, so you can build a whole lot of terms. For example, it's possible to tie the gift to the purchase of a house, education, or overseas travel. So I showed you that. Essentially, you want to start to build that into the terms and conditions on a broad basis for the client. But again, these are only things that you'll learn with practice anyway. If you get Abbott Mourly engaged in that process, so you've built the testamentary trust documents, these are the questions that we're going to ask your client anyway. So it gives you an ability to sort of listen, and then over time, you'll actually be able to complete it all yourself. Income flexibility, it's a discretionary trust, so we don't need to say anything more. Okay, so the special disability trust, do you just want to go through that one, Tony, what a special disability trust is?
Yeah, special.
I know we've built a few of those ones.
Yeah, so we did one probably about 2 months ago for a client too. So an STD is a special type of trust that allows, parents and immediate family.
Maybe call it an SDT, not an STD.
Well, yeah, STD. Okay.
SDT, not STD. Yeah, they're different.
No, SDT.
Yeah, exactly.
Yeah. SDT. Okay. Is a special trust that allows parents and individual family members to plan for current and future needs of a person with severe disability. Okay. So if an immediate family member transfers assets into the SDT, generous concessions are available to benefit both the contributor and the beneficiary of that trust. And there's tax and social security concessions that are intended to encourage family members to make future arrangements for the beneficiary with that, with severe disabilities in that regard. And there's some of the key benefits.
So some of the key benefits when we have a look down that track, this is, you can put these in through the testamentary trust. Remember, I wrote it down here. I think I put it in here. So for example, no beneficiaries received, blah, 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 blah. Or I could put in here, if it was Max and building it for young William. So the trust is to be a special disability trust for Centrelink and, sorry, the typing there, Centrelink and tax purposes. And if you're having a problem about what you really want to put in there, please feel free to give Tony and myself a call at any time. We're more than happy to walk you through anything there, which is pretty crucial. So again, key benefits, obviously legal planning. That's anyone who's got a disabled child. Obviously, one of the biggest problems or biggest worries is who's going to look after them on their passing. For Social Security, there's a $500,000 gifting session, a gifting concession for eligible immediately family members. And also there's an assets test exemption of $694,000. So that's the 2021 financial year, which is quite sizable from an assets test perspective. And obviously net income tax of the lower rate. But on top of that, we can also have the superannuation. I think it's important. I'll send through, there's quite a lot on SMSF Wills versus binding death benefit nominations. But again, it's really important to plan, because traditionally you'll go to a lawyer and the lawyer will simply pass it into the estate, whereas Section 62 of the SIS Act enables it to go to a dependent or the trustee, the legal person representative. Make sure it doesn't go to the trustee of the legal estate, because it'll be null and void. So what we do there's two things. We've got, for a retail superannuation fund, you can pay directly to a dependent, which includes a spouse, child, or financial dependent. The only problem when you have a look at a retail superannuation fund, it depends on what they allow you to do. Although the law basically says that a child dependent can take a pension if they're under age 25, definitely under age 18, but if they're under 25, they need to be financially dependent, but it can only ever go to age 25. There's probably not that many, there's certainly not that many retail or industry funds that would enable you to pay a child pension. But we could have, in this instance, the pension going from John to Sally and then going to the disabled child, provided we can show that John, so the disabled child is financially dependent upon John. So we can show that continuous provision of income or an allowance to look after that disabled child. Then on death, it could go from John to Sally and then to disabled William. Or if Sally's not alive, it just go from John to disabled William. Now, because that's a grandchild, these rules don't apply. We can receive that income stream by way of dependency. So that's a multi-generational reversion pension. Again, a dependent who's not a child can take a pension. So I just talked about a account-based pension. So that's for our grandchildren. Alternatively, death benefits can be paid to the deceased legal estate. Important to secure with a binding death benefit nomination, etc. If it's a self-managed super fund, it's the same with retail, but obviously we use an SMSF will. It's basically a lot broader and a lot more secure than a BDBN, which is the laws only apply to retail superannuation fund. It can be paid to bloodline only if we wanted to, and we can actually have multi-generational pensions, such as I just talked about before. And a lump sum can be paid to a dependent for payment to a trust, or you can actually create an SMSF testamentary trust, which sits outside the will. So that's all covered in our SMSF will, and if I took you through that data capture, you would see that as well, which is pretty crucial. The final one, which is pretty important, and again, just on that protector side, next week we'll be letting you know, but we'll be going into that protector and also registering charges, so that Michael, do you just want to talk about that next for a couple of minutes on the PPSR side and what you can, what you're able to do for people?
Sure, Grant. We'll be going through that, but effectively we'll be able to provide PPSR registration, whether that means a loan and security agreement document back or just the PPSR registration services, and it'll be through an efficient service through one of our partners, Aventum Optimum.
Which would be fantastic. So we'll let you know on that one, and they'll be crucial, and Mick will take you through a couple of things there. One of the things we have to look at, sorry. It's
quite paramount that it's done right. There's obviously been, which we'll go through next week, but there's been certain cases that where it has been done wrong, it's cost multi-millions of dollars. So.
Yeah, I saw one for $20 million, which was a bit of a stuff up.
Yeah.
With the family provisions claim, so this is the one that needs to go over. We talked about it earlier, and I'll leave that. I don't want to go into detail, but this is from New South Wales. It's the same in most states, but any eligible person can make a claim if they feel they've been left out or haven't been appropriately provided for. So when we come down to this element, this is the one that you really need to keep in mind for all your clients. The first thing is, is there anyone who's going to challenge your estate? Because if I took you right down to the case study here, one of the issues there that I'd be asking, one of the issues I'd be asking John and also Sally for that matter is, look, it's a great idea for Max to have that property, but how's both Sarah and Jody going to feel about that? Because they can effectively make a family provisions claim. There's a good chance that they'll probably end up with a couple of $100,000, which will be very problematic for Max, because he may end up having to sell that property, or the executor will have to sell that property or split it 3 ways. So again, if you've got that potential that Sarah and Jody are going to make a claim on the estate, and they're going to feel aggrieved, then essentially that's where you'll probably use the protector rather with a family protection trust rather than building a comprehensive testamentary trust. Even if you build a testamentary trust and you make all these claims, it still have to go through the executor. The executor will be challenged before it can actually make any of those claims, remember, because there's a potential liability there. So you just got to be very careful. At any point in time, you can contact myself or Tony. So Anamourlis, I'll leave all the details anyway for you. If there's a specific issue there, either give us a call or Tony will arrange a Zoom where we can cover 2 or 3 issues there for your clients. Again, if you're part of light year docs, there's just a part of the ordinary service, and then we can help you out there. And if we got anything else we need be, then we'll do that as well. But if there's no further questions, what we'll do is we'll just shut up shop there. I've got one further question. So we covered that around the protector. We'll get this up and running. There's 2 CPE points and 2 CBD points. So again, thank you, Tony, for putting in your great effort and building all these slides. And also, Mick, thank you for your ideas around the accounting. Certainly look forward to that PPSR next week, which is absolutely crucial when we're looking at all of this sort of stuff. So anyway, it's Grant and Mick and Tony signing off.
Thanks, man.
Bye.